Hi, I'm Janet Payton. I'm a partner in McGuire Woods Intellectual Property Group. Welcome to episode 2 of our Frenemies series. Don't worry if you haven't seen episode 1 yet. You can watch these episodes in any order. If you did watch episode 1, you know that our Frenemies series is based on the natural tension between lawyers and the marketing folks. Sometimes the marketing team members may even avoid talking to the legal team. Yes, this really happens until the last possible minute or even later about what kinds of trademarks are most likely to make the best brands and which ones can you really own without a big uphill battle at the trademark office. In this episode, we'll talk specifically about the timeline for trademark registration and the connection between applying for a trademark and using it, and the timing of both of those things, and how to make sure that you don't accidentally lose your trademark rights. So let's start with a quick review of why apply for a federal trademark. When you own a federally registered trademark, you are the presumptive owner of the mark throughout the United States. So when you walk into court with someone in a fight over a trademark, if you are registered as the owner, you win, unless the other side can overcome the presumption that you're the owner by putting on evidence. Think of it like the presumption of innocence. But you're the presumptive owner, and the court believes that you're the owner unless the other side can overcome that presumption and prove otherwise. Having a registered mark also gives you the right to use that encircled R symbol. That symbol functions as a deterrent to infringers. When they see it, they know that the mark is registered, somebody's paying attention, and they shouldn't use it for purposes of their own. Lastly, it gives you access to the federal courts. Federal court is really where you want to be in a trademark dispute. There are not as many IP judges at the state level. Generally, state judges are not familiar with intellectual property law. So in the federal court system, you're more likely to have a judge that understands intellectual property. And if you need to appeal, there's actually a court that hears all IP appeals. So it's really the place you want to be, and it gives you automatic access. These are the key stages of the trademark registration process. The first stage, and a really important one, is preclearance. This is when we check to see if we can register the mark. Is it going to infringe someone else's rights? Is it likely to be refused by the trademark examiner? Or does it look like a great mark that can go through the process and get registered? Preclearance usually takes somewhere between 1 to 7 days. In other words, best if you have a little time, but it can be done quickly. It should always be done before you apply to register. Then the application itself can take anywhere from 6 months to over 3 years, and we'll talk about why in the next few slides. And finally, once you do get your mark registered, you have to keep it. You have to do some activities to maintain it with the trademark office, and you have to always continue to use it. You cannot maintain a mark and you cannot renew it if you haven't been using it. So use is important. But as long as you do those things, you can keep it forever. You can maintain it and it will stay registered until the end of time. So it's unlike other kinds of IP that expire no matter what you do after a certain period of time, like patents and copyrights. Trademarks can go on forever as long as you take care of them. So let's first talk about preclearance, that first step. We think of it in 2 stages. The first stage is what we call the knockout search. This is just a quick, inexpensive online search to see if there's any really obvious problems that are so obvious that you don't need to go any further. You can just knock that one off your list. So a knockout search isn't the final word on whether a mark is available, but it's an important first step because you wouldn't want to go to a full search, which is more expensive, when you could have knocked that one out with a cheap online search. So the best way to use this search is to get a list of potential candidates and start with knockout searches on all of them and get a sense of which ones are still in the running. And then from that list, pick a favorite and run a full search on the favorite. The full search is a very comprehensive search. It tells you much more about what's going on with a mark. because it not only searches the US Patent and Trademark Office using some more sophisticated search logic than is just available for free online, but it also will search common law marks, websites, domain names, all kinds of content, state databases, for example, because trademarks can be registered at the state level sometimes, and also business names. So it's a very comprehensive search, and it's definitely one that you want to do once your knockout search comes back clear. So then, let's say you've finished that preclearance, you've got a great mark, and it's clear, you want to apply. The application process takes a lot of time. The fastest possible application is going to be a 6 or 7 month process. But remember, using the mark is not dependent on the application. You can use the mark even before you apply. If you've done a preclearance search and you're comfortable that it doesn't infringe anyone, go ahead and use it. You're not waiting to register it. So it shouldn't hold up your use of the mark. But if you haven't started using the mark yet, it's a great idea to apply early because you can get this long kind of drawn out process going before you launch and get a sense of whether the trademark examiner is going to let it through before you invest a lot of money in it. So when you apply, you submit your mark. If it's a word mark, you just submit the word on the application, or if it's a design, you need to submit a high resolution image of the design. You have to decide if you're going to claim color and font and those kinds of things as elements of the mark, or if you just want to protect the word in any font, any format. You have to decide what goods and services this is going to be a brand of. There's a common misconception that trademarks just protect that word for everything. You know, you thought of a cool word and you're just going to register it as a trademark. A trademark has to be a brand of something. It's a brand of shoes or a brand of banking services. You have to list what it's a brand of in the application. You can list more than one thing, but you do have to eventually use it for all of those things. So choose your goods and services. If you haven't started using it yet, go broad because you can always narrow it later, but you can't add things later. Then you also need information about who is applying, the corporate applicant. So you need address, name, legal name of the corporation. You can include a DBA if you want to, but make sure it's got the legal name and the DBA. It has to have a real physical address. You can't list a PO box. And then you have to list the state of incorporation for corporate applicants. If it's an individual filing as an applicant, then you just list your address. So then you've got your application on file. It usually takes about 3 months to hear from the trademark office from the date that you file, roughly. And when you hear from them, you're going to hear one of two things. Either you'll receive an office action, which means there is some hiccup. The examiner has some issue or concern with the application. If you get an office action, you have 6 months to respond. And if you resolve the issue with your response, then the application is back on track and will move forward towards publication. If you don't resolve it, you'll get another office action, and that one will be final. And if you can't resolve it with that one, then you're going to be dead in the water. So let's say you overcome the office action and you move forward. The next step is publication. About 3 or 4 weeks after you resolve your office action, or not very long after that 3 months runs, if there was no office action, you'll get what's called a notice of publication. This is a signal that you're past the examiner, you're good to go to the next step, and then the mark is published in the official gazette of the US Patent and Trademark Office. This scintillating book describes every trademark that has been applied for and gotten past the examiner in that week. And it's an opportunity for third parties to object to the mark being registered. So the trademark examiner has looked at it and said that they don't see anything that's already registered or pending in front of you that should block your application. But that doesn't mean there isn't an owner out there that would disagree and say, no, this is too close to my mark. It's like a 30-day comment period. So during that publication period, other owners can file an objection, which is called an opposition, or they can request an extension of time to file an opposition. Often if they request an extension of time, they'll actually reach out to you, and maybe you decide to reach out to them to see if you can work something out before they actually oppose. But if none of that happens and the 30-day period closes, then you're at a crossroads. At this point, you're at a crossroads. Up until now, it really didn't matter whether the application was based on your use already or if it was an intent to use application. But now the road diverges into two different directions, depending on whether you're already using the mark and have proved use of the mark to the trademark office already, or if you have not. If the mark is in use and you have already submitted specimens of use with your application and a date of first use, then at this point, your mark's going to proceed to registration. You're good to go, and you're likely to get a certificate pretty soon. If there was no use yet, if it was intent to use, once you come out of the 30-day publication period, you get a notice of allowance. What this means is that you're approved, you're good to go, but you haven't started use yet. And you cannot have a registered trademark without use. So now a clock starts running. For intent to use applications, you have 6 months from the notice of allowance to prove use of the mark in commerce for all the goods and services that you listed, or you can delete some and prove use of the rest, or request an extension of time. So you can get extensions if you're not ready in the first 6-month period to prove use. Your application will just remain pending at the trademark office until you do prove use. And every 6 months, you'll have to request another extension of time. And there is a fee associated with the extension of time per class. At the moment, that fee is $125 per class, but of course that could change. And if you get all the way out to the 3rd anniversary of the notice of allowance and you still have not proved use, the application will abandon and you'll have to go all the way to the back of the line and start over. So this is a timeline that shows from the filing what the sort of life cycle of a trademark is on the USPTO registry. As I said, from the filing date to examination, it's about 3 months. And then you'll hear from the examiner either that you've gotten an office action, in which case you have 6 months to respond, or that you're moving forward to publication and you have a notice of publication that tells you the date that your mark will be published. Usually you get that notice several weeks in advance of the actual date. Then when it's published, there's a 30-day period for others to object. Once that publication period closes, if the mark was in use, it will go forward and register. If it wasn't in use, then you're in that holding pattern that we talked about until you prove use, and then it registers. Once it's registered and you're at that registration point on this timeline, your mark will remain on the registry registered for 6 years. Between the 5th and 6th anniversary, you have to prove that you're still using it and swear under penalty of perjury that you've been using it the whole time for all the goods and services that are listed in it. Again, if you're not using it for all of them, you can drop some and just prove use of the others, but you cannot keep that mark registered without use. So once you prove use, then you're good to go until the 10th anniversary and every 10th anniversary thereafter. Every time you come up on a 10th anniversary of the trademark registration, you again have to prove use and swear under penalty of perjury that you've been using the mark continuously in commerce for all those goods and services since the last time. So as I said, if this is an intent to use application, the timeline is a little bit different because after publication, instead of going straight to registration, you get that notice of allowance. And then you have that somewhere between 0 to 3 years whenever you can actually prove use to move forward to registration or die, abandon. Once you get registered though, you're exactly the same as the other applications. You have 6 years from the first registration date, and between the 5th and 6th year, you have to prove that you're still using it, and then get the 10th year and every 10th year thereafter. So once it's registered, as I said at the beginning, you've got it forever. You've got that mark as long as you keep using it, and it's yours and you're the presumptive owner. So unlike patents and copyrights, you can keep it as long as you keep using it, but make sure that you really are using it the way that it was registered and for the things that it was registered for. Because remember, if you registered it for shoes and now you're using it for banking services, you don't have protection for that. Make sure you've got the things listed that you need, and if you ever need to add things, you file a new application for those. So hopefully that all makes sense. In the end, it's just really important to use them consistently. So let's just talk for a minute about these symbols. While you're in this trademark process, before the mark gets registered, it's appropriate to use the TM or SM symbol, and you often see that as a superscript at the end of the mark. It's not required, but it's a good idea because it does function as a deterrent. When people see it, they know it's a trademark and they shouldn't use it because it's not theirs. Once it gets registered, you have the privilege of using the R symbol. And so you should do that. It's a good idea. But as I said, if it's not appropriate somehow, if it doesn't fit, you don't have to use it every time. It's just a really good idea to use it as much as possible. It also puts people on notice such that if you got into a litigation situation, you'd have a stronger claim for willful infringement, and the damages for that are much higher. So it's a great idea to use those symbols. The difference between the TM and the SM is simply the difference between a mark for goods and a mark for services. So in my earlier example of shoes, if you have a brand of shoes, you would use TM because shoes are goods. If you have banking services as whatever you're using your mark for, then that's a service, and so it's a service mark, and you would use SM while your application is pending. Think of this sort of like patent pending that you see printed sometimes on machines that include inventions. This symbol, TM or SM, indicates that your application is pending, or even if you haven't filed one, that you're asserting common law rights in the mark. Once it gets registered, then we don't distinguish anymore between goods or services. It's just registered. Thank you for watching episode 2 of our Frenemies series. I hope you'll join us again for episode 3, which will feature my colleagues Lucy Wheatley and Amanda DeFord. Please don't hesitate to reach out to me or your primary McGuire Woods contact if you have any questions about the content of this video. In the meantime, I hope you're starting to feel a little more warm and fuzzy toward your marketing and legal colleagues. Thanks.